Okay, welcome to Unit 6, Professional Responsibility. It's funny how falling feels like flying for a little while. So let's get at it. One thing I've noticed about your book, the textbook, the Problems in Legal Ethics, the 11th edition, is that when they give you a table of contents in the beginning of each chapter, they don't really follow it. Very interesting. Also, for your discussion problems, the reading material that follows them really doesn't cover all the discussion problems either. So basically, I'm not quite sure what this book's good for, other than these discussion problems are good and they get us to discuss the actual rules and how the rules should be applied. It'd be nice if in the reading material they'd give us some examples, but you know, it's only a $250 book, so we can't ask for everything. Okay, so let's get going. One of the things they said is take a look at the model rules, and part of the focus of the reading assignment and the discussion for Unit 6, which is supposed to include professional discipline for lack of competence or diligence, liability for malpractice, and authorized practice and other relations with non-lawyers. Comment 4, these are from the preamble and scope of the model rules. It says in all professional functions, a lawyer should be competent, prompt, and diligent. We'll be going through those rules. A lawyer should maintain communication with the client concerning the representation. A lawyer should keep in confidence information relating to representation of a client, except so far as disclosure is required or permitted by the rules. So that's basically a summation of the rules, ABA Rules of Professional Responsibility 1.1 to 1.6. Number 7, comment 7 in the preamble, or of the preamble. Many of a lawyer's professional responsibilities are prescribed in the Rules of Professional Conduct as well as substantive and procedural law. However, a lawyer is also guided by personal conscience and the approbation of professional peers. A lawyer should strive to attain the highest level of skill to improve the law in the legal profession and to exemplify the legal profession's ideals of public servant. That basically says, look, the ABA model rules aren't all that you're required to do. And 20, violation of a rule. This is about malpractice and being sued. It said comment 20, violation of a rule should not itself give rise to a cause of action against the lawyer, nor should it create any presumption in such a case that a legal duty has been breached. Okay, so just because a rule has been violated doesn't mean that your client or a third party has a course of action against you simply for the violation of a rule of professional conduct. The rules, as in the Rules of Professional Conduct, are designed to provide guidance to lawyers and to provide a structure for regulating conduct through disciplinary agencies. And each jurisdiction, each has their procedures and process in their agencies in which they conduct discipline. And of course, the Supreme Court or the highest court in each state or each jurisdiction is the final say when it comes to discipline for lawyers. The rules are not designed for the basis of civil liability. Nevertheless, never a good word, nevertheless, since the rules do establish standards of conduct by lawyers, a lawyer's violation of a rule may be evidence of a breach of applicable standard of conduct. So therefore, these rules are not so lawyers would get sued if they violate them, but it could be evidence in a malpractice case that the standard of care that a lawyer is required to give to his client has not been met. Okay, so that's done with the preamble. Let's go on to the rules. First rule we have is Rule 1.1, and that has to do with competence. The biggest thing about this rule is not that you need to be an expert going into everything, but you need to bring competence. And competence, a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So how can you get the legal knowledge, skill, and thoroughness? Well, you can do it by preparation, even if you've never practiced in a specific or certain area of law before. For example, comment 2. A lawyer can provide adequate representation in a wholly novel field through necessary study, meaning a field that's brand new to them. Competent representation can also be provided through association of a lawyer of established competence in the field in question, but of course your client needs to know about whether you're going to bring another lawyer in with you, and they have to be fully informed, and there are other considerations and requirements as well. So you can become competent through study, necessary study, or bring someone in who knows what they're doing and have them teach you. Comment 6. Before a lawyer retains or contracts with other lawyers outside the lawyer's own firm to provide or assist in the provision of legal services to a client, the lawyer should ordinarily obtain informed consent from the client, there you go, and must reasonably believe that the other lawyer's services will contribute to the competent and ethical representation of the client. So the client has to be on board, and remember about fee splitting and things like that also go in line when you start to bring a client or a lawyer from outside your firm with you. We had one discussion problem here. Which one is it? It's one where the woman wants to bring someone from outside the firm in because she doesn't like the woman in her firm. I think it's number 9. Who has competence or expertise in the matter. The tricky part about discussion question number 9 is that this is a woman in a firm who has the needed expertise in the firm from another lawyer but wants to go outside the firm. So much more than just Rule 1.1 applies here. What about the fiduciary responsibility of the lawyer to their own firm not to take business away from that firm? So that's something that has to be considered for discussion question number 9. Comment 8. To maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, engage in continuing study and education, and comply with all continuing legal education requirements to which the lawyer is subject. Those of you who are going to take the Washington, D.C. bar exam, you do not have any continuing legal education requirements. That makes it one of the better bars as far as continuing legal education is required. But that is a requirement if you do indeed take California or Washington State, or you get licensed in any other jurisdiction. There are continuing legal education requirements or CLE requirements, and you are required to comply with those requirements in order to maintain your competence as an attorney in that jurisdiction. Okay, client-lawyer relationship. This is a restatement of law governing lawyers' formation of client-lawyer relationship. This also deals with one of the discussion questions. How do you know when a person becomes your client? Well, on page 179 of your textbook, it paraphrases Restatement of Law Governing Lawyers, section 14.1, and it says, a person, and directly quoting, a person can become a client simply by asking the attorney for legal help. If the attorney does not decline to give the help, and if the attorney knows or should know that the person will reasonably rely on the attorney to give help. That could be important for discussion problem number 1 in your reading assignment. Okay, the scope of representation and allocation of authority between client and lawyer. what is within the purview of the attorney, the decisions that they are to make, and what is in the purview of the client and the decisions they are to make, and thus the attorney who's representing them must abide by those decisions. Well, subject to paragraphs A and D, a lawyer shall abide by a client's decision concerning the objectives of representation. And I think that specifically applies to discussion question number 5. And then it goes on to say, a lawyer may take such action on behalf of a client as impliedly authorized to carry out the representation. That oftentimes, or that may be talking about the tactics in which the attorney will need to take. Then it goes on to say a lawyer shall abide by a client's decision whether to settle a matter. So the client's got the authority, as the ultimate authority is whether to settle a matter. In a criminal case, the lawyer shall abide by the client's decision after consultation with the lawyer as to the plea to be entered. Okay, so the defendant is ultimately responsible for the plea to be entered. The defendant is ultimately responsible for whether to waive a jury trial, and the defendant is also ultimately responsible as whether the defendant will testify. And of course, after consultation with the lawyer. What's interesting about that is that on a lot of movies or whatever, you'll see a defendant will say, there's no way my lawyer will let me testify on my own behalf. Well, this rule specifically states that it's not up to the attorney to make that decision. Ultimately, after consultation with the lawyer, the client has that decision. The defendant has that decision. Okay, and again, that last sentence applied to criminal cases. B, a lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities. What's interesting about this rule is that in the United States, when federal judges are nominated, they go before a hearing before the Senate. And depending upon whether the senator likes you or not, they'll often bring up past clients. And they'll inure to you the endorsement of those clients' political, economic, social, moral views or activities. And a lot of these senators are also attorneys, and they know it's just a bunch of gunk when they do that, because based on the law rules, hey, everybody, especially when it comes to defendants in criminal cases, require legal representation within the American justice system. And just because you have certain people as clients doesn't mean you agree with them on everything. Nonetheless, the idiots in the United States Senate always play that dog and pony show when it comes to, oh, well, you represented big business, so you're against the little guy. Oh. I can't stand the United States Senate. Sorry. C, a lawyer may limit the scope of the representation if the limitation is reasonable under the circumstances and the client gives informed consent. That also goes to discussion question number 5. As you see in the in that question, you see the hiring attorney from the Infoscope Incorporated is very much trying to limit the representation within certain confines in order to reduce costs. I think we also have a comment that we'll see on that. D, a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent. Hopefully that's obvious. But a lawyer may discuss the legal consequences of any proposed course of conduct with the client and may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of law. Basically, that says you can't engage or assist a client in criminal or fraudulent conduct. However, if a client comes before you and asks you to do so, or says, how about we do this, and you know it's criminal or fraudulent, you can counsel them and say, hey, this is criminal and fraudulent. Doesn't necessarily mean you have to step away from the client. All right, well, we didn't have any comments on that. Read the comments for that. So, diligence. Here's another one. A lawyer shall act with reasonable diligence and promptness in representing a client. Comment 2, a lawyer's workload must be controlled so that each matter can be handled competently. So this diligence means that if an attorney in a firm is assigned a case, those people who are assigning the case, those attorneys with managerial authority and managerial responsibility, which could assume senior associates and partners, any attorney within who has managerial authority, who's assigning cases, as well as partners in the firm, are responsible to make sure that their attorneys can act with reasonable diligence and promptness in representing a client, and they have to make sure that they don't overload a younger lawyer or a less experienced lawyer with a workload where they can't control the matters and can handle them competently. Yeah, good luck with that. Okay, comment 3, perhaps no professional shortcoming is more widely resented than procrastinations. Okay, not doing what you should do and the time that you should, putting things off to the end, oftentimes that jeopardizes your case, especially when it's running up against the statute of limitations. Reading on, it says, a client's interest often can be adversely affected by the passage of time or change of conditions as well. Memories fade, people disappear, meaning witnesses disappear. What else? Evidence gets lost. In extreme instances, as when a lawyer overlooks the statute of limitations, we mentioned that earlier, the client's legal position may be destroyed. Even when the client's interests are not affected in substance, however, unreasonable delay can cause a needless anxiety and undermine confidence. So, procrastination is not acting with reasonable diligence and promptness in representing a client. Comment 5. Okay, this has to do with acting with diligence if you're a sole practitioner. If something happens to you, either disabling you or causing you death, you need to set up a plan that who's going to take care of my clients if I can't. And that's what comment 5 is all about. 1.4, communication. Okay, a lawyer shall promptly inform the client of any decision or circumstance with respect to which the client's informed consent, as defined in Rule 1.0e, is required by these rules. Well, one example of that is informed consent if, in a civil case, if a client is offered a settlement offer, okay? The lawyer must promptly inform the client of that settlement offer because the circumstance in that needs the client's informed consent as to whether to take that offer. A lawyer shall reasonably consult with the client about the means by which the client's objectives are to be accomplished. Remember, the objectives are the purview of the client, and the tactics are the purview of the attorney and how to meet those objectives. But it says that the lawyer shall reasonably consult with the client concerning them. A lawyer shall keep the client reasonably informed about the status of a matter. You don't want to cause the client to basically have to call you to get updates. You want to provide them and be proactive with updates. Of course, you don't need to give updates every day. You usually should inform the client on a regular basis, and especially when anything happens of any substance in the client's case, such as a court date, a hearing, whether you'll be taking depositions and things like that. A lawyer shall promptly comply with reasonable requests for information. Reasonable requests for information, okay? A lawyer does not have to promptly comply with any request for information, any and all requests for information, and a lawyer shall consult with the client about any relevant limitation on the lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the rules of professional conduct or other law. So if a client wants you to do something that you know you can't do, you need to tell them about it. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. So, for example, in case of a settlement offer, the lawyer should explain to them for one thing, if they go to litigation, the expense of litigation, the extra time of litigation, how strong the case is or how weak it is, how good or how bad the offer is, the amount of money, what they think the lawyer could calculate based upon what they think they might get in litigation, and all, those kinds of things, so the client can make an informed decision concerning that issue and other issues like that. It's the same thing in the criminal case with the plea bargain. They have to consult with the client, the defendant in that case. Same types of things, strengths of the case, what type of years that the client might get if they took this to trial and a jury found against them, those types of things in order for the client to make an informed decision. Okay, number 2, if these rules require that a particular decision about the representation be made by the client, paragraph A1 requires that the lawyer promptly consult with and secure the client's consent. So, for example, we talked about whether to accept an offer. That has to be made by the client. In a criminal case, a plea bargain, whether to waive a jury trial, those types of things, they have to be promptly communicated to the client because they make those decisions. Okay, it does say unless prior discussions with the client have resolved what action. So if the attorney already knows what to do and is given clear instructions, then they don't have to promptly consult because they've previously consulted. All right, so the comment goes into a settlement offer. All right, let's go on. Okay, 1.8, conflict of interest, current client specific rules. Your reading assignment said only to look at 1.8H, and Rule 1.8H says a lawyer shall not make an agreement prospectively limiting the lawyer's liability to a client for malpractice unless the client is independently represented in making the agreement. Couple of things here. There are, I think, 3 or 4 examples in the book where a third party and not a client can sue an attorney for malpractice, but usually the person suing an attorney for malpractice has to be a client. And in this case, you can't agree prospectively to limit the lawyer's liability unless, of course, the client is independently represented in making the agreement to do such limitation. Or a lawyer shall not settle a claim or potential claim for such liability with an unrepresented client or former client unless that person is advised in writing of the desirability of seeking and is giving a reasonable opportunity to seek the advice of independent legal counsel in connection therewith. Now, 2 doesn't require an independent legal counsel. 1 does. However, 2 requires a writing of the desirability that, hey, I'd like to settle a malpractice claim with you, the unrepresented or former client, but you need to go seek independent counsel to determine whether this settlement claim that I'm offering you is a good offer. You don't have to do it, but it's desirable that you do so. And the client could say, nah, I'm just going to settle now. I don't need to get another attorney involved because guess what? I'm going to have to pay the other attorney. Comment 14 for Rule 1.8 says this paragraph does not, however, prohibit a lawyer from entering into an agreement with the client to arbitrate legal malpractice claims. So basically, you're not limiting the lawyer's liability or you're not presenting any type of settlement, so you're not violating Rule 1.8 H1 or 2. If you agree with the client to arbitrate legal malpractice claims up front. Now, in some jurisdictions, arbitration of legal malpractice claims are not enforceable. The agreements are just not enforceable. The courts will not accept them. So, you have to know what jurisdiction you're in. Okay, duties to prospective client. There wasn't nothing in your reading or in the discussion questions about duties to prospective clients, but basically you have to treat a prospective client like a regular client when it comes to things of confidentiality and conflict of interest and things like that. Rule 1.18 goes through it. It's a long rule. Take your time going through it. Look at the comments. Okay, law firms and associations. Okay, that's the overall general heading, and we're into Rule 5.3, responsibilities regarding non-lawyer assistants. Okay, so basically, in law firms in the United States, non-legal professionals such as paralegals, secretaries, administrative assistants do a lot of legal work, but they have to do it supervised by an attorney. Okay, as long as they do that, it's fine. Now, of course, they can't appear in court supervised an attorney, but they can do research, they can write things, they can write things that are being filed with the court, but of course the supervising attorneys, they have to sign off on this stuff. So A partner and lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the person's conduct is compatible with professional obligations as a lawyer. So basically, the lawyers have to make sure that the non-lawyers meet the ABA rules of responsibility too, or ABA rules of professional conduct. But of course, a non-lawyer is not subject to discipline under these rules. However, the supervising attorney is. A lawyer having direct supervising authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. Otherwise, the lawyer can be subject to discipline. Of course, the non-lawyer will not be. A lawyer shall be responsible for conduct of such a person that would be a violation of the rules of professional conduct if engaged in by a lawyer if. Okay, so they're going to be responsible if the lawyer orders or, with the knowledge of the specific conduct, ratifies the conduct involved, or the lawyer is a partner or has comparable managerial authority in the law firm in which the person is employed, or has direct supervisory authority over the person, and knows of the conduct at the time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. There's a multiple choice question in the back that deals with this rule. Let's go on. Comment 2. All right. Lawyers generally employ assistants in their practice. Okay. These are the non-lawyers, secretaries, investigators. Investigators often go out and find witnesses and interview witnesses and take information prior to an attorney going to do a deposition on those witnesses. They also are they also go out and accumulate evidence. Also, law student interns such as yourselves and paraprofessionals, so paralegals. I guess paraprofessionals is a new euphemism for paralegals, because I guess paralegals is somehow offensive. Who knows? Such assistants, whether employees or independent contractors, act for the lawyer in rendition of the lawyer's professional services. So they help the lawyer. They help the lawyer in the lawyer's practice. A lawyer must give such assistants appropriate instruction and supervision concerning the ethical aspects of their employment, particularly regarding the obligation not to disclose information relating to representation of the client. That's Rule 1.6, confidentiality, and should be responsible for their work product. I don't know, should be. I mean, I think that should means they shall be. They are responsible for their work product. A non-lawyer cannot be responsible for legal work product. The supervising attorney must be. The measures employed in supervising non-lawyers should take account of the fact that they do not have legal training, okay? Although some paraprofessionals, aka paralegals, have wonderful, wonderful legal training if they've worked for a while within a practice. Paralegals often have a lot of legal knowledge, and they know the practice of law, and they know the procedural aspects of law. However, they don't have law degrees. So, therefore, they say they do not have legal training. And then finally, and are not subject to professional discipline. As I stated before, only lawyers are subject to professional discipline under the rules of professional responsibility. under the disciplinary procedures of the bar and ultimately the highest court in their jurisdiction. Professional independence of a lawyer. Okay, a lawyer or firm shall not share legal fees with a non-lawyer. Okay, so one of the things, if you see a lawyer going into business with a non-lawyer and part of the business is the practice of law, can't do it. Okay, because that would be sharing legal fees with a non-lawyer. However, there are exceptions. An agreement by a lawyer with the lawyer's firm, partner, or associate may provide for the payment of money over a reasonable period of time after the lawyer's death to the lawyer's estate or to one or more specified persons. So this really is legal fees with the lawyer, sharing them, but the lawyer's dead. So it goes to the lawyer's estate or some other representative. Except that a lawyer who purchases the practice of a deceased, disabled, or disappeared lawyer may, pursuant to the provisions of Rule 1.7, pay to the estate or other representative of the lawyer the agreed upon purchase price. Again, this has to do with really a lawyer would ordinarily get this money, but he's died or disabled or he's gone. Except that a lawyer or law firm may include non-lawyer employees in a compensation or retirement plan, even though the plan is based on whole or in part on a profit-sharing arrangement. So, for example, if you win a case, you can't give a non-lawyer employee a percentage of the fees that you were awarded in that case, or that you generated in that case, or that you won in that case. However, you can allow for a non-lawyer to be compensated based on the overall revenue or net income of the firm. Okay, you can't tie them to a specific case and fees from a specific case or award money from a specific case, but you can tie the compensation package to the overall profitability of the firm. And you can also include them in retirement plans, which God is only fair, right? Okay. Except that a lawyer may share court-awarded legal fees with a nonprofit organization that employed, retained, or recommended employment of the lawyer in the matter. So, for example, the Alliance Defending Freedom, which is a religious freedom nonprofit organization. It actually is a law firm, but the way it works is it has a network of attorneys throughout the United States and now throughout the world. They will take this network of attorneys and look to see an attorney in a jurisdiction where an infringement upon someone's religious freedom has come up, and they will recommend that person to take the case. And in that case, if they win and have court-awarded attorney's fees, they can share those fees. B, a lawyer shall not form a partnership with a non-lawyer if any of the activities of the partnership consist of the practice of law. You guys are studying business associations. Rule B is specifically concerning partnerships. C, a lawyer shall not permit a person who recommends, employs, or pays the lawyer to render legal services for another to direct or regulate the lawyer's professional judgment in rendering such legal services. A lawyer must maintain their independence and the tactics and their judgment on how, based upon the goal of the representation of their client, to achieve that goal through their legal judgment and the tactics that they think are best for their client. Of course, that must be in consultation with the client. It shouldn't be based upon what a third person or a third party wants, especially those who have recommended, employed, or paid based on this rule. Okay, a lawyer shall not practice with or in the form of a professional corporation or association authorized to practice law for a profit if a non-lawyer owns any interest therein, except that a fiduciary representative of a state. Okay, a non-lawyer is a corporate director or officer there or occupies a position of similar, or has the right to direct or control the professional judgment of the lawyer. Okay. Comment 2. This rule also expresses traditional limitations on permitting a third party to direct or regulate the lawyer's professional judgment in rendering legal services to another. There's a discussion question number 5 that deals with this rule and deals with this comment. So therefore, I'd pay close attention to it. Rule 5.5, unauthorized practice of law. A lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction or assist another in doing so. We've gone through this before. If you're not licensed there, you can't practice law. There are certain or if you don't meet any of the exceptions, you can't practice there. A lawyer who is not admitted to practice in this jurisdiction shall not, except as authorized by these rules or other law, establish an office or other systematic and continuous presence in this jurisdiction for the practice of law. Remember, later on in this rule, it talks about in-house counsel, and if you're in-house counsel, you can establish systematic and continuous presence. They also have the pro hoc vice, also the federal practice, and the patent attorneys and things like that. They are exceptions to this rule. A lawyer shall also not hold out to the public or otherwise represent that the lawyer is admitted to practice law in this jurisdiction. Okay, number 5. This is an interesting comment. It says the definition of the practice of law is established by law and varies from one jurisdiction to another. So, for example, in discussion problem 1, when the woman went on the internet and asked about whether she had a malpractice case against her attorney, and the attorney from another jurisdiction answered that question, was she practicing law at that time? Well, there's no universal definition for the practice of law, and of course the reading assignment didn't provide any, nor do the comments really provide any other than this comment, which says that it varies from one jurisdiction to another. Okay, it goes on. This rule does not prohibit a lawyer from employing service of paraprofessionals and delegating functions to them. We already went through that. They are required, though, to supervise them and would be subject to discipline if they did not do it correctly. Okay, here we are at the end. These are the similar California rules that you'll see that are similar to the rules that we've just discussed. You have the professional integrity in general. Unauthorized practice of law is 1-300. Rule 1-310, forming a partnership with a non-lawyer. And Rule 1-320, financial arrangements with non-lawyers. Then we have professional relationships with clients. Rule 3-110 is failing to act competently. Rule 3-400, limiting liability to a client. Rule 3-500 is communication with a client or clients. Rule 3-510 is communication of settlement offer. So those are similar California rules. I would strongly encourage you to read those rules. They are very similar to the rules that the ABA has promulgated and the rules that we went over. Okay, so that's it for Unit 6. Hope you enjoyed it. God bless.